Hey, what's up, guys? Welcome back to True Crime Unraveled. I'm your host, Robert. Now, we all received a very big gut punch today with Judge Hippler not only denying the Franks hearing, but denying all the emotions to suppress as well. And one of the documents I want to go over today is the Order on Defendant's Motions to Suppress RE, AT&T, Google, USB, Apple, and Amazon. Now, this is a really big document, so I'm going to be breaking it up into several videos. The first one I'm going to go over today is the AT&T. Defendant is charged with one count of burglary and 4 counts of murder in the first degree in connection with the stabbing deaths of 4 University of Idaho students in the early morning hours of November 13th, 2022. As part of law enforcement's investigation, the Federal Bureau of Investigation issued federal grand jury subpoenas to Apple and Amazon to obtain information from accounts linked to the defendant. The FBI provided responsive information to detectives from the Moscow Police Department who requested and received search warrants for the Apple and Amazon accounts. In addition, detectives sought and obtained search warrants for defendants' Google accounts, a USB drive containing defendant's cell phone data, and for information held by defendant's cellular carrier, AT&T. Before the court and defendant's motions to suppress the information obtained through the subpoenas and the AT&T, Google, Apple, and USB search warrants, defendant argues that the FBI issuance of the subpoenas uh, constituted a warrantless search that violated his privacy interests under both the Fourth Amendment and Article 1 and 17 of the Idaho Constitution. He further argues that the search warrants failed to command a search and or lack particularity. The state responds that defendants relinquished any privacy interests he had in the Amazon and Apple materials and further contends the remaining warrants are proper and sufficiently particular. A suppression hearing on the portion of defendant's motions at issue in this order was held on January 24th, 2025, during which the court received testimony from both Detective Corporal Brett Payne and Detective Lawrence Mallory, both from the MPD. The court found both detectives to be credible and reliable. Following argument, the court took the matter under advisement. The court finds suppression is not warranted because, number one, defendant relinquished any privacy interests he had in the record subpoenaed from Amazon and Apple to the third party doctrine, and two, the remaining search warrants are valid. Well, where my problem with this is, guys, is Judge Hippler never really wanted this case. Uh, even when he first got the case, well, it's nice to meet you, but I wouldn't want to tell a half truth. Personally, I think Judge Hippler just wants this thing to go straight to trial and let Brian to be found guilty or innocent by a jury of his peers because he don't want this case in his courtroom. And that's just my thoughts on that, in my opinion. The standard of a motion to suppress is bifurcated. The power to assess the credibility of witnesses, resolve factual conflicts, weigh evidence, and draw factual inferences is vested in the trial court, State versus Valdez Molina. A trial court's ruling on a motion to suppress evidence combines the issue of law and fact, and the trial court's factual findings will not be overturned unless there are clearly erroneous, yeah, which I do believe, everything going on in this case is erroneous. When a decision on a motion to suppress is challenged the application of constitutional principles to the facts found will be freely reviewed. And that was State versus uh, Veneroso, 2003. On the finding of the facts, on November 13th, 2022, an officer from the Moscow Police Department responded to a residence located at 1122 King Road in Moscow, Idaho, where he discovered the bodies of Madison Mogan, Kaylee Gonzalez, Ethan Chapin, and Xander Kernodle. Each appeared to have been stabbed to death. Now that's not what we heard numerous times over the last 2 years. They all had different injury patterns. For purposes of the investigation, the investigation that ensued was a multi-agency affair involving members of the Moscow Police Department, the Idaho State Police, and the FBI, among others. For purposes of the investigation, a command team consisting of several investigators from each of these agencies were set up at the Moscow Police headquarters. The command team included, among others, Detective Brett Payne, Detective Lawrence Mowry of the Moscow Police Department, as well as Special Agent Nicholas Balance of the FBI, all of whom were co-located on the second floor of the Moscow Police Department. The command team met twice daily for several weeks to review, analyze, and organize the information gathered in the investigation. Pertinent information was transmitted into a working probable cause affidavit that could be and was incorporated by law enforcement into their various search warrant affidavits. All investigators had access to the search warrant affidavits issued during the investigation. So you had the MPD who had access to the search warrants, and you had the FBI who had access to the search warrants, and you had the IFP who had access to the search warrants. Yeah, there's too many hands in the cookie jar in that scenario right there. And I do believe so. I believe, in my own opinion, that there was too many hands in the cookie jars when it comes to the search warrants. You had the FBI, the ISP, and the MPD all working with the same search warrants. Among the initial search warrants sought in the investigation were two to AT&T, the cell carrier, for a phone number that law enforcement had linked to defendant. Detective Payne applied for and received both warrants on December 23rd, 2023. On 2022, my bad. Now, see, well, here's the thing. They let him drive clear across the country. He was already in Pennsylvania when these search warrants went out for the AT&T. So why didn't they bring him in for questioning long before he left for Pennsylvania? I mean, that's something that we will never know. Because he left for Pennsylvania, I believe it was on the 15th or the 16th, and he drove there with his dad, and he got pulled over twice by Indiana State troopers for the same thing. But they didn't send out the search warrants for the AT&T cellular carrier until the 23rd of December. As Detective Payne was not an expert in cell phone data, he relied heavily upon Agent Balance, who is a member of the FBI's Cellular Analysis Survey Team, or CAST, and specializes in cell records analysis. Agent Balance aided Detective Payne in both drafting the search warrant affidavits for the AT&T warrants and analyzing returned information. Within a week of obtaining the AT&T warrants, law enforcement obtained a warrant for defendant's arrest. The arrest was effectuated on December 30th, 2022, at his parents' home in Pennsylvania. At that time, law enforcement seized defendant's cell phone pursuant to a search warrant for their home to reserve the phone's data. The FBI copied the contents of the cell phone onto a USB drive, but did not review the contents. Law enforcement also had a warrant to search defendant's vehicle, which was located in the garage of his parents' home. During the search of the vehicle, a receipt for an Apple iPad was found. Following defendant's arrest, the FBI obtained uh, served two federal grand jury subpoenas, one for Apple and one for Amazon. In addition, Detective Payne and/or Mallory obtained search warrants for records from Google, Apple, Amazon, and for the contents of the USB drive. Well, see, here's what's weird though. The FBI didn't they do the search warrants or the grand jury subpoenas, one to Apple, one to Amazon, but then you have Detective Payne and or Mallory doing the same thing for Google, Apple, and Amazon. The first AT&T warrant Detective Payne applied for sought 9 categories of records associated with the defendant's cell phone. 1, customer subscriber information. 2, device purchase information. 3, associated email addresses. 4, call detail records. 5, cell site information. 6, cell site locations. 7, location information for the cell phone. 8, text and MMS message. And 9, cloud data. See Exhibit S1 to first AT&T objection. Each of these categories were narrowed by a detailed description of the specific information sought. The information requested was temporarily limited to a 48-hour period, November 12th at 12 a.m. to November 14th at 12 a.m. In his accompanying search warrant affidavit, Detective Payne set forth in detail that the circumstances of the crime and the scope and the result of the investigation as of that date, including evidence linking defendant to the suspect vehicle seen on surveillance videos around the time of the murders. Detective Payne indicated how each of the categories of information sought would aid the investigation, including in determining whether the phone's activity was consistent with the suspect vehicle's route of travel as seen on the surveillance videos, whether the phone was in the vicinity of the murders during or prior to its occurrence as part of planning the crime, and why the defendant's phone was not reporting to the network during the estimated time of the crime occurred. Now, see, they're saying here that they have videos of the suspect vehicle, but according to Brett Payne and according to Ann Taylor, they didn't pick his car up anywhere. Based on Brett Payne's search warrant affidavit, the magistrate issued a search warrant for the records sought therein. The warrant stated in relevant part, Brett Payne having given me proof upon oath this day showing probable cause, establishing grounds for issuing a search warrant and probable cause to believe property consists of certain evidence regarding the investigation into the crimes of homicide at 1122 King Road in Moscow is on the AT&T account associated with the phone number 509-592-8548 between November 12th, 2022 and November 14th, 2022. The warrant that set forth each of the categories of information defined by Detective Payne in his search warrant affidavit. It was served by Detective Mallory upon AT&T via email, as was Detective Mallory's practice. He did not include Detective Payne's search warrant affidavit with the warrant when serving it. AT&T emailed upon return of the requested information back to Detective Mallory later that day. The returned information was immediately turned over to Agent Balance for review and analysis. In reviewing the information, Agent Balance had access to and knowledge of Detective Payne's search warrant affidavit, the first AT&T search warrant. So I'm like blown away with this affidavit. I'm also blown away with the fact that Judge Hippler uh, denied everything. Basically, denied the motions to suppress, denied the Frank's hearing motion, and is an innocent man going to die for this? In all honesty, is an innocent man going to get convicted and sentenced to death? I do believe so. Now, I want Brian to be innocent, and they say that they have evidence, but that we haven't seen. You know, is there evidence that we haven't seen? Probably, but I want to see it, and I'm not going to be able to see it until trial. But this is video 1. I'm going to be recording video 2 here in a little bit, and I'm going to be talking about the pen, trap, and trace in that video. Let me know down in the comment section what your thoughts are with what Judge Hippler did today. This is True Crime Unraveled. Y'all have a good Thursday. Peace.